essentially 3 levels of writing competence: core, passable, and strong. So how do we go from one level to the next? How do we go from core to passable, or from passable to strong? Writing for a non-lawyer audience is really important, even if your audience is actually a lawyer, because it's easier to read, it's easier to comprehend. To build a story arc, you should start with a big picture overview. Repeat keywords and phrases to signal relatedness between paragraphs and sentences. One of the things that you want to keep in mind is, even though the product that you're delivering is written, if your writing is pleasing to listen to, it will also be pleasing to read.
My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speaker, David Kemp. David Kemp is an adjunct professor at Rutgers Law School. He teaches several legal writing courses as well as professional responsibility. He is also the managing editor of Verdict, a website offering legal analysis and commentary, and the OIA Project. He received his BA in psychology from Rice University and his JD from Berkeley Law, where he served as the senior executive editor of the California Law Review and co-editor-in-chief of the Berkeley Journal of African American Law and Policy. David will be joining us for a live discussion with Marina and an audience Q&A portion at the end of the webinar. So if you have any questions that come up during the webinar, please click that button that says Q&A at the bottom of your screen and submit your questions. Without further ado, here is David to discuss how to write like the best legal writers.
Welcome. Today we're going to cover how to write like the best legal writers. On the agenda for today, I'll introduce myself, and then I'll focus on how we can write like the best legal writers, looking at 3 in particular. In conclusion, we'll cover a few extra resources in case you're interested in further reading, and then I'll take questions at the end. So let's start with the introduction. My name is David Kemp. I graduated from Berkeley Law. I am currently the managing editor of Justia's OIA and Verdict. I'm also an adjunct writing professor at Rutgers Law School, and I formerly taught legal writing at Berkeley Law. While I was a student at Berkeley Law, I was a senior executive editor of the California Law Review. And in these roles, I see all sorts of writing by practitioners, by academics and judges, elected officials, and of course, students. And I see essentially 3 levels of writing competence: core, passable, and strong. Core writing contains objective errors, grammatical mistakes, typos, and so on, and usually is a product of insufficient writing or editing time and a lack of knowledge or skill. Passable writing contains few objective errors, but writing style is just incidental. For example, there may be organizational issues, or flow or transitions, superficial conversation, such as, you're talking in a foreign language that you don't really know that well. You can talk about the weather and other things, but you can't engage in those deep, meaningful levels of conversation that have several levels of meaning. And strong competence has no objective errors, makes deliberate style decisions such as word choice, sentence length and sentence order, structure, and big picture organization. So how do we go from one level to the next? How do we go from core to passable, or from passable to strong? Besides spending more time on the writing, which sometimes we have the capacity to do, and sometimes we're constrained by our resources or by hiring it out, we can read and emulate strong writing to become stronger writers ourselves. So let's look at how really good legal writers do what they do. That's what we're going to focus on today, is looking at strong writing from nearly universally acclaimed legal writers. So I've broken down the tips for today into a few things that I think are sort of universal. So regardless of whether you're writing an appellate or a trial brief, a judicial opinion, perhaps even communications with clients and colleagues, whether you're writing for law journals, blogs, websites, whatever, I think that these principles will improve your writing regardless of what type of writing you're doing. There's certainly far more techniques, but they're beyond the scope of what we can cover in 1 hour. So based on my experience teaching and doing writing, these 5 stand out as being particularly helpful in improving writing. And to visit these techniques, we're going to use 3 different vehicles for learning. I've chosen 3 passages by 3 of the most renowned writers: Justice Elena Kagan, the late Justice Antonin Scalia, and the late Justice Robert Jackson. So I've chosen actually 3 dissenting opinions, in part because I feel that the dissents, or through the dissents, their individual voices really come through. And in fact, the Scalia and Jackson pieces are both lone dissents, whereas Kagan's is joined by 2 other justices. So just as a preview, in case you're not familiar with these cases, in the Brnovich case, Justice Kagan lamented the majority's decision in Section 2 of the Voting Rights Act. In the Morrison case, in Scalia's dissent, Justice Scalia is criticizing the majority for undercutting executive authority by permitting the appointment of independent counsel. And in Korematsu, Justice Jackson is criticizing the conviction and detention of a Japanese-American man during World War II, or leading up to World War II. So the reason that I chose these 3, and in addition to these justices being so revered for their writing, is that they really reflect a lot of experience and education and process in writing. Each of these justices, or especially Justice Kagan and Justice Scalia, have talked extensively about the writing process and how much time it takes. And that's one of the keys here is to spend the time both in the writing process, but also the editing after you've written. Justice Kagan is sometimes recognized as the best writer ever on the Supreme Court. Princeton, Oxford, and Harvard trained. In an interview with Brian Garner, Kagan said, "The most important thing in a brief is clarity." And her writing really exemplifies clarity. Justice Scalia, we all know also as a really highly regarded legal writer. He went to Georgetown, Harvard Law, and he's known for his biting wit and precise writing. He actually co-authored 2 books with legal writing guru Brian Garner, including Making Your Case, The Art of Persuading Judges. And Scalia says, know your audience. So advocates hinging on his vote knew, for example, not to press arguments based on legislative history or policy. And finally, Justice Jackson is often cited as one of the best writers in Supreme Court history, including by a majority of the current sitting Supreme Court justices. So that speaks a lot to his regard and as a legal writer. So let's look at how to write for a non-lawyer audience. Writing for a non-lawyer audience is really important, even if your audience is actually a lawyer, because it's easier to read, it's easier to comprehend. So the ways that you can do that, the 3 things that I think are easiest or most accessible for writing for a non-lawyer audience is to avoid jargon, define legal terms of art, and use examples and analogies. As Kagan says, focus on clarity. And does this conflict with what Scalia says, know your audience? If you're writing for a lawyer audience, does writing for a non-lawyer audience conflict with Scalia's advice? And I would say, no, it doesn't. So even in areas where I consider myself well-versed, clear and simple, but not pedantic writing is far more enjoyable to read. And something that's more enjoyable to read is easier to comprehend. So let's take a look at one of the examples. In Brnovich, Justice Kagan writes, "If a single statute represents the best of America, it is the Voting Rights Act. It marries 2 great ideals, democracy and racial equality, and it dedicates our country to carrying them out. Section 2, the provision at issue here, guarantees that members of every racial group will have equal voting opportunities. Citizens of every race will have the same shot to participate in the political process and to elect representatives of their choice. They will all own our democracy together, no one more and no one less than any other." So let's look at some of the techniques that Justice Kagan uses here. First of all, the sentences are very short. She uses simple phrases, simple words, and this is the beginning, so she starts very broadly. She's talking about the Voting Rights Act in broad terms, not this precise statutory language yet. And one of the things that this accomplishes is it brings the reader in. It makes it very accessible for the reader, and she's giving us the direction of the opinion that she's going to take us. Let's look at another example here. This is from Scalia's dissenting opinion in Morrison v. Olson. Scalia writes, "That is what this suit is about, power. The allocation of power among Congress, the presidents, and the courts in such fashion as to preserve the equilibrium the Constitution sought to establish, so that a gradual concentration of the several powers in the same department can effectively be resisted. Frequently, an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf." One of the things that Scalia does really effectively in this passage is he juxtaposes very long and complex sentences with much shorter sentences. But this wolf comes as a wolf carries the emphasis of a very short sentence to conclude that paragraph, and starting the paragraph with another short sentence, two of them actually. That is what this suit is about, power. It's hard to get more clear and more direct than a sentence like that. He also effectively uses this metaphor of the wolf and the sheep, a metaphor that most of us are very familiar with and something that relates what this issue is about in a way that's very accessible for us. Finally, Justice Scalia talks about not just what this issue is, which he does, it's about power, but also he talks about what this issue is not. And sometimes describing what something is not about can help clarify what it is. Finally, in Korematsu, Justice Jackson writes, "Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to this country. There is no suggestion that, apart from the matter involved here, he is not a law-abiding and well-disposed. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born, and where all his life he has lived." And in writing this way, Justice Jackson draws us in to understand Korematsu's story, who he is as a person, because that's the focus of his opinion. That's what his opinion turns on, is how can we deny the civil rights to this person simply by who he is. The second tip is to build a story arc. To build a story arc, you should start with a big picture overview. Repeat keywords and phrases to signal relatedness between paragraphs and sentences, and conclude with the highlights and takeaways. And coaching people to do public speaking, one often says, tell them what you're going to tell them, and then tell them what you told them. And the same thing holds true in writing. So let's look at a few examples of how these justices do that in their writing. In Brnovich, Justice Kagan writes, "If a single statute reminds us of the worst of America, it is the Voting Rights Act, because it was and remains so necessary. Because a century after the Civil War was fought, at the time of the Act's passage, the promise of political equality remained a distant dream for African American citizens. Because states and localities continually contrived new rules, mostly neutral on their face, but discriminatory in operation, to keep minority voters from the polls. Because Congress had reason to suppose that states would try similar maneuvers in the future, pouring old poison into new bottles to suppress minority votes. Because Congress has been proved right." Justice Kagan uses the word because 4 times in a row, ending with the strongest and shortest one. And what she does over the course of this paragraph is to explain why a single statute reminds us of the worst of America. She starts big, she starts abstract, and then explains why that first sentence is so true, ending with, because Congress has been proved right. She follows this arc of a story, starting with something broad and then explaining it further and further using repetition to draw those sentences together to arrive at the culmination of this whole paragraph that Congress has been proved right. Here's a tip that we often see Scalia not do, but it's still worthwhile to investigate. And that is to use shorter sentences and smaller ideas. So studies have shown that shorter sentences are easier to understand. Readers understand at least 90% of 14-word sentences, but only less than 10% of 43-word sentences. So the shorter your sentence can be, the easier it is to understand. And also, focus your paragraphs on a single topic. More focused paragraphs are easier to follow. And we saw that in in all of the previous examples that we've looked at, that the writers are really focusing on a single topic in a paragraph and then transitioning to another paragraph. Let's see what Justice Jackson has to say about that. He writes in Korematsu, that the law which this prisoner is convicted of disregarding is not found in an act of Congress, but in a military order. Neither the act of Congress nor the executive order of the president, nor both together, would afford a basis for this conviction. It rests on the orders of General DeWitt. And it is said that if the military commander had reasonable military grounds for promulgating the orders, they are constitutional and become law, and the court is required to enforce them. There are several reasons why I cannot subscribe to this doctrine. Some of the things that Justice Jackson does here, again, is saying what this is not. He says, it is not this. This would not work. Only that, and let me tell you why. And so the way that Justice Jackson puts all of this together really makes this a compelling story. It uses these shorter sentences. It rests on the orders of General DeWitt. There are several reasons I cannot subscribe to this doctrine. Those are the sentences Justice Jackson wants us to pay most attention to. They are the shortest sentences, and they're the most emphatic. Our fourth point is to eliminate passive voice and wordiness. So just as a review, passive voice emphasizes the object and de-emphasizes the subject. For example, if you said a new rule was proposed by the EPA, that's passive voice because the emphasis is on the rule, but the action is actually by the EPA. The action is to propose. In contrast, the EPA proposed a new rule is the active voice. The EPA is the subject and the one doing the action. The new rule is what action was acted upon. Use passive voice deliberately and sparingly for the purpose of emphasizing the objects and de-emphasizing the subjects. Most of the time, active voice is superior to passive voice. It uses fewer words and it's more direct. Let's look at Justice Scalia using active versus passive voice. The major fortification provided, of course, was the veto power. But in addition to providing fortification, the founders conspicuously and very consciously declined to sap the executive's strength in the same way they had weakened the legislature, by dividing the executive power. Proposals to have multiple executives or a council of advisors with separate authority were rejected. In the first part of this paragraph, Justice Scalia used the active voice. The founders conspicuously and very consciously declined, the focus of this sentence being on the founders declining. The sentence that follows de-emphasizes the founders to put the emphasis on the rejection of proposals. Proposals were rejected. They were rejected by the founders, but Scalia has chosen to put that sentence in passive voice because he doesn't want to emphasize that the founders were the ones who rejected the proposals. He's emphasizing that the proposals were rejected. This last tip is to finalize your writing by reading it aloud. And many of us don't have the luxury of time to be able to do that. But when you do read aloud your work for the purpose of doing editing and proofreading, you'll notice awkwardly long sentences and be able to revise them. You can catch minor typos and correct them. You can also address tongue twisters and mouthfuls. One of the things that you want to keep in mind is even though the product that you're delivering is written, if your writing is pleasing to listen to, it will also be pleasing to read. And especially when you're writing for a judge who is skeptical to begin with of your position, perhaps, who is busy. You want your writing to be easy to read so that your arguments are easy to digest and understand, and your side is easy to favor. Let's take a look at Justice Kagan using this. This court has no right to remake Section 2. Maybe some think that vote suppression is a relic of history, and so the need for a potent Section 2 has come and gone. But Congress gets to make that call. Because it has not done so, this court's duty is to apply the law as it is written. The law that confronted one of this country's most enduring wrongs pledged to give every American of every race an equal chance to participate in our democracy, and now stands as the crucial tool to achieve that goal. That law, of all laws, deserves the sweep and power Congress gave it. That law, of all laws, should not be diminished by this court. Now, when I hear this passage, it sounds very much like President Lincoln's Gettysburg Address. That law of all laws should not be diminished by this court. Lincoln said, "That government of the people, by the people, for the people, shall not perish from the earth." What Justice Kagan here is doing is invoking the way these words sound. This sounds like someone invoking action. I almost guarantee that someone in Justice Kagan's chambers read this passage out loud at some point, because it's so poetic, it's so beautiful, and it's so rhythmic. Of course, not all of the briefs or memos or letters that we write can be poetic, but reading out loud the words that we're writing on the page can really signal to us how the reader is perceiving them. And we can elevate our writing by thinking about it, hearing it ourselves, and writing it so that it can be listened to. Let's take a look at the way Justice Scalia implements this. The ad hoc approach to constitutional adjudication has real attraction, even apart from its work-saving potential. It is guaranteed to produce a result in every case that will make a majority of the court happy with the law. The law is, by definition, precisely what the majority thinks. Taking all things into account, it ought to be. I prefer to rely upon the judgment of the wise men who constructed our system, and of the people who approved it, and of 2 centuries of history that have shown it to be sound. Like it or not, that judgment says quite plainly that the executive power shall be vested in a president of the United States. Again, the way that Scalia writes here is nearly poetic. He excoriates the other justices, the court, for taking this ad hoc approach to constitutional adjudication, saying we must rely on what the founders originally intended. And of course, we know that Scalia says this in different ways in many different places. But the way he says it here is rhythmic, it flows, and it sounds like something that is supposed to be read aloud. Finally, let's take a look at Justice Jackson's writing in a way that can be heard. My duties as a justice, as I see them, do not require me to make a military judgment as to whether General DeWitt's evacuation and detention program was a reasonable military necessity. I do not suggest that the courts should have attempted to interfere with the Army in carrying out its task, but I do not think they may be asked to execute a military expedient that has no place in law under the Constitution. I would reverse the judgment and discharge the prisoner. So here, again, Justice Jackson is calling to the reader to hear his words, and he's using this repetition that we talked about, shorter sentences, what is not, to really emphasize his point that is not the role of the military or of the courts to uphold the conviction of Korematsu here. So I'd like to conclude by just pointing you to a few other resources that reiterate a lot of what we said, but also go beyond what we've covered in this webinar today. Several of the points here come from various resources. Ross Guberman's Points Made is an excellent book. It's in its 2nd edition, and he pulls in a similar way to what we did today, he pulls from some of the strongest brief writers across the country at all levels of the courts, and points out passages or entire paragraphs or even pages from their briefs, pointing out what they do so well and why it works. He divides it into numerous chapters, focusing on a different theme in each one. It's very accessible, and the way that it relies on examples, I think, is a very effective tool for anyone who writes persuasively, because it really demonstrates using examples what works well and what works less well. So I strongly encourage you to refer to that book if you ever have to write persuasively. A second book that's very helpful is Brian Garner's The Winning Brief. Brian Garner is probably the legal writing guru. He's interviewed basically all the justices about writing specifically. He's written all of the major authorities on legal writing, and it's a really excellent brief, a really excellent book about persuasive writing again. And then taking a step back from persuasive writing specifically, there's this other book by Armstrong, Terrell, and others, Thinking Like a Writer, A Lawyer's Guide to Effective Writing and Editing. I find that book is an excellent resource as well, not just for persuasive writing, but for any kind of writing. It breaks things down into bite-sized pieces. Again, uses lots of examples to illustrate how things work well, what makes things work less well, and it has exercises as well to let you practice improving your skills. So that's all great. But for those of you who don't have time to study up and practice on the excellent prose of the great legal writers of yesterday and today, there are some tools that make it easy to improve your writing. I'd like to talk about 3 tools in particular: the built-in spell check and grammar check in Microsoft Word, a web-based tool called Grammarly, and the newest technology that has recently been in the headlines, ChatGPT. Now, these aren't a substitute for a skilled human writer and editor, but they can definitely help you improve your written product. So let's first look at Microsoft Word's spell check and grammar check. So anyone who's ever typed a document in Microsoft Word is probably familiar with its spell check and grammar check tools. Spell check has been a feature of Microsoft Word's word processing program since the early 1990s, but it's evolved significantly since then. Originally, you would have had to affirmatively run the spell check and grammar check, which would then review your document for unrecognized words and strings of words that seem to violate the rules of grammar as they were encoded into the software. That was great for catching some typos, but if your mistyped word was simply a different word, such as statue instead of statute, early versions of spell check would not catch that. But over the years, we've seen it evolve and improve. It checks as you type, indicating objective errors with a squiggly red underline, and frequently offering relatively high-quality suggestions for fixing word choice, passive voice, and other issues affecting readability. It also fixed the statute versus statue problem and others kind of like that. But even with these advances, it still cannot replace the work of a strong human writer and good editor, particularly when it comes to big picture techniques like the story arc and the complexity of ideas that we talked about. So let's look at a slightly more sophisticated tool. Let's have a look at Grammarly. So Grammarly comes a little bit closer. It started in 2009 as a web-based grammatical error correction tool, and it quickly became popular among students and professionals across industries because of its speed and adaptability. Grammarly uses cutting-edge technologies now, like natural language processing and machine learning, to offer suggestions not just for incorrect words or misspellings, but for full sentence rewrites, tone adjustments, consistency, and readability. And again, while Grammarly cannot replace a human editor, it definitely helps weak and average writers refine their skill not by merely suggesting changes the way Microsoft Word's tool does, but explaining those suggestions as well. In fact, I use Grammarly for myself for all documents that I produce, student assignments, professional correspondence, and more. And I also recommend to my students and colleagues that they use Grammarly for all of their written products. I view it as one step above spell check and grammar check, and it continues to improve and get more sophisticated and more precise in the way it suggests improvements in writing. As an educator, I also use Grammarly for a neat feature that allows you to check for duplicate content. This can be an effective tool for checking for plagiarism, but for content creators, it can also help ensure that your content is sufficiently unique for SEO purposes. And that brings us to the most advanced writing tool, and one that is a hot topic in the news right now, ChatGPT. So ChatGPT is a chatbot launched by OpenAI in November 2022. You can ask it to perform countless tasks, which it executes almost instantaneously. And among these tasks, for our purposes today, is the drafting of various documents. So let's see how it performs. In this case, I asked it to draft a cease and desist letter regarding the unauthorized use of copyrighted material. If you look over this letter, it looks okay, it's not bad. It seems to be pretty good at drafting these form letters like this one. But for anyone who sends these types of letters on a regular basis, you probably already have your own templates that's far better than what ChatGPT can produce. So let's try something a little bit more nuanced. In this instance, I asked it to draft a 500-word blog post for a law firm website describing the Supreme Court's decision in Ariano v. McDonough, which was decided in late January. It did a terrible job. It gets the facts and the issues completely wrong, and while some of the statements are correct, such as what the Equal Protection Clause is, which I did not include in this excerpt, overall it completely misses the mark. You can see the OIA summary in contrast. It talks about completely different legal issues. The mechanics of the writing, however, are impressive. If we ignore the substance, we see that it starts with a general conclusion, it then goes in to provide some background, and then explains the significance of the decision. So the words, the sentences, the paragraphs all flow smoothly, and it employs a number of the techniques that we discussed in the first part of this webinar. So it's not about to replace me as the editor of OIA anytime soon, but unlike the other two tools we looked at, it can generate content from scratch rather than simply checking or improving something that you or someone else wrote. And I expect to see huge advances in its factual accuracy in the near future. Here's another example. And this time, I asked it to draft one paragraph of marketing language for a personal injury law firm. And having written and read more of these than I can count, I can say that ChatGPT did a really good job with this task. I dare say that this is better than what I've seen on a lot of law firm websites. And finally, let's see how it does with the legal question. In this instance, I've asked it an ethics question that the State Bar of California's Committee on Professional Responsibility and Conduct recently addressed in an ethics opinion. What ethical obligations arise when a lawyer represents a client whose case is being funded by a third-party litigation funder? As you can see, and if you look closely and read carefully the parts that I did not include here, its answer pretty closely tracks the digest that the committee itself wrote. Both identify confidentiality and independent professional judgment as the main ethical issues. So what does all this mean for attorneys? Right now, ChatGPT is not going to replace a human writer when it comes to documents that require factual knowledge, but it seems to be pretty good at rule-based analysis and writing. Now, I think that it can be a helpful tool, at least as a starting point, for some types of documents and writings because of its ability to quickly produce writing that follows generally accepted norms for effective communication. Substance-wise, it has a long way to go. And there are some fascinating ethical issues of technology that are beyond the scope of this webinar. But I would encourage all of you to take ChatGPT for a test drive to see how, in conjunction with spell check, Grammarly, and your own human eye, you can become a more effective writer. So that's it for today's webinar. Thanks for tuning in. If you have questions, you can reach me by email, on Twitter, LinkedIn, and so on. Thanks so much.
Thanks, Nina, and thank you, David. Thanks to all of you for being here. I hope that was, interesting and shared some great new information with all of y'all. now that we had David here to talk with us and have a little bit of a discussion, I know one of the hot new things that's in the news, he talked about it, everybody seems to be talking about it, is this AI, Chat GPT, similar things like it. So David, I mean, I'll let you take it away. I guess the first really burning question here for you is, I mean, how important is Chat GPT going to be? I mean, is this revolutionizing how we write for our practices? Is it writing demand letters, legal documents? What are the limitations?
Absolutely. I think it's something that we really want to pay close attention to. It's something that has been sort of simmering for a while. I think those who are well versed in technology are probably aware that it's been around for, or these types of technologies have been around for a while. But it's just now coming into sort of the public view, and there's this awe and fascination with what it can do, and sort of it's I think it's very impressive. And I think as we get, it builds on more and more people using it and getting that data and getting the input and the feedback on that data. And so as it gets this greater acceptance and greater um, use in the general public, I think it's going to start growing and improving very rapidly. As I pointed out, I don't think it's going to replace anyone yet, any human writers or editors. But I think it's very close to being a tool that we should all consider as something that will make our work more efficient, perhaps more thorough, and something that we should probably embrace rather than reject, both as educators, but also as practicing attorneys. I think it holds a lot of promise.
No, that makes sense. And so if I'm, the kind of lawyer who I like to be on the cutting edge of things, I'm willing to try it out. So, I see this new thing. I mean, how much of my work can it replace? Could it write my whole brief for me? I mean, is it dealing with facts, legal issues? Where does that line stop, do you think? Are there ethical concerns?
All of the above. Well, we'll take that one piece at a time. So it definitely is not ready to write your briefs for you. As we saw from some of the examples, it's not very good at getting the facts right. And so if something is fact heavy, or you may have to input some of the facts, it just may just get things completely wrong. So it's definitely not ready to do a lot of those parts of legal writing for you. One of the things that it can do potentially, and this is something that I'm playing around with in terms of how I'm teaching law students, is how does it construct these sentences and the paragraphs and entire passages of sentences and paragraphs, and how do we learn from that and improve upon that, right? So maybe Chat GPT will produce a paragraph for us that talks about a case, and we go in as humans and facts check to make sure, is this correct? But what it does is it starts off with a clear topic sentence that tells what the holding was. Maybe we adjust it to be more precise, but then it goes in and gives some of the background. Maybe it gives the procedural history. Again, that's a strong way of structuring a paragraph. And so we can learn from that. So I think at sort of a micro level, I think if we ask it to write a sentence, and we give it fairly specific directions, I think it's already pretty good at that, and it's only going to improve. A paragraph, it's going to run into a few more problems. And again, we can give it some feedback, and it will continue to improve. Entire sections, entire briefs, entire documents, I think it's a long way from being able to do that. But as with any tool, I think in the hands of people who really know what they're doing already, it can be very effective in making your time more efficient. Right. So if I'm an expert in copyright law, I might be able to ask very precise, directed questions, and use it to help me draft a sentence or come up with an idea that I might have eventually gotten around to, but it's much faster at it. So it's certainly in the hands of someone who knows the terminology and knows what questions to ask. It can be potentially very, very powerful. To the second part of your question about the ethical issues, there's a whole host of ethical issues that I alluded to in the presentation, but we can sort of touch on a few of them now. I think that because I think they're really fascinating. And one thing that I would hesitate to do is I think that often we say, oh, there's a whole host of ethical issues, we should just reject it outright. And I think that would be the wrong approach. I think with technology like ChatGPT or AI and machine learning more generally, we should investigate those ethical issues and figure out how can we get ahead of the curve? How can we address those at the outset, right early on, so that they don't become problematic later? And some of the ethical issues associated with ChatGPT specifically include copyright. So ChatGPT, we don't know exactly how it works. It could be drawing from sources that are copyrighted materials, and then spitting that back out to us and saying, look at what I created from my, AI black box. But that's something that we would have to be certain of so that we don't run afoul of copyright law. As an educator, one of the things that I am acutely aware of is that students might find it very appealing. If they've got a deadline coming up, and a lot of students always have deadlines coming up, to turn to ChatGPT and say, hey, can you help me draft this first draft of this this memo that I have to write for class or something like that. And so plagiarism, there may be plagiarism issues there as well. So if does the student, is that plagiarism if the student just asks ChatGPT to draft something for them? There are other contexts as well. I mean, for lawyers, we also can get in trouble for plagiarism. And so to what extent do we need to disclose that something that we've written or that we claim we have written was actually generated by ChatGPT? The ethics rules in most states are pretty clear that we cannot mislead in stating that maybe we wrote something when in fact we didn't. So there's certainly ethical issues around that as well. And then one final, there are a bunch, but one that I think is really fascinating as well is this idea of confidentiality. So we are privy to lots of confidential clients' information, and to draft anything about those clients or related to those client matters, we would probably have to give ChatGPT some of that confidential information, and that would potentially run afoul of ethics rules. So there's a lot of nuance to ChatGPT for sure. Certainly, there are these ethical issues that we should investigate and look to see what can we do about them from the outset. But I think it's exciting technology, and I think we should embrace it rather than reject it, because it is the future. It's here, and it's only going to become more and more pervasive in all sorts of professions, but I think especially in the legal profession.
Yeah, no, I mean, those are definitely great insights. And I have a follow-up discussion question for you, but there's some limitations here, but we can embrace it to really help transform our practices. So I guess a related question for that legal research and that writing component of things is Westlaw. So I don't know how much attention you pay to Westlaw and, day in, day out, but, legal research matters. And I think that, Westlaw is venturing into this from what I've seen. They've got some hybrid research and writing tools, some AI they've got going on there. I mean, do you have any insights into that and whether or not it is more effective for lawyers than ChatGPT?
I do think that any of the AI related tools that Westlaw and Lexis are developing are going to be more helpful for lawyers than a general tool like ChatGPT, at least for now, because those major companies are focused exclusively on tools to help lawyers. They've got huge teams of people working on them and making sure that whatever they're producing is sufficient for their subscriber base. And ChatGPT just has a sort of a different approach and a different focus. It's much more aimed at the general public for right now. And so I think Westlaw and Lexis are both going to be more reliable sources for things that's specifically for lawyers, at least for the near future. That said, I think that we would be remiss by ignoring ChatGPT as it pertains to law and the practice of law and legal education as well, because it's really going to go in different directions from what I think Westlaw is going to do. Especially, Westlaw is helpful for research for sure. I mean, some of the most interesting advances that they've introduced recently have to do with suggesting cases that you might not have cited or that you didn't cite that you might be interested in reading, or cases that your opponent cites, or if you upload via someone else's brief, cases that they don't cite, or maybe that might have been overturned since it was written. So that kind of stuff, I think Westlaw and Lexis are going to far excel ahead of what ChatGPT is going to be able to do for now, because the makers of ChatGPT are just not interested in those features or in that functionality. And so for those reasons, I think that Westlaw and Lexis and the products that they produce that are based on AI will for a while be much more helpful for lawyers, even if they're not as awe-inspiring or impressive as ChatGPT. I think that from a practical standpoint, they're probably going to be more reliable.
Well said. And I know you touched on this a little bit, but talking in terms of reliability, ChatGPT is easy to access. It's free. If I'm, a solo or I'm working on a budget and I'm using Fastcase or other free legal resource solutions, I'm not using Westlaw. I guess there is kind of a question mark there is, can ChatGPT help me with the law? Can I ask it a legal question? Will it give me the correct answers? Or do I need to be cautious there as well?
You can ask it a legal question. It will give you an answer, but whether it's the correct answer is up in the air. And I think one of the things that we're finding just in the tests that I've done is that sometimes it gives an answer that's close but not quite right. And sometimes it'll give an answer that's completely wrong because ChatGPT doesn't really have an understanding of how the law works or legal principles. So, for example, this morning I asked whether same-sex marriage is legal in Georgia, and it said no, which we know is not legally accurate. But what I did was ChatGPT is sort of a two-way street. It's not just a ask it questions, it spits out answers. So I said, that's incorrect. And I pointed it to the Obergefell Supreme Court decision, and it responded and said, "Oh, I'm sorry. It's not illegal in Georgia based on this Obergefell decision." And then I had a conversation with it and said, "Is it now? So when was it legalized?" And it gave me the decision date for Obergefell. So it is learning. It's constantly learning, but it's definitely, it doesn't have a sophisticated or even primitive understanding of how the law works. So ask it a legal question at your own peril. But I think, and factual questions as well, I think it's just not quite there yet. But it's interesting. It's learning. I read an anecdote earlier today that a judge in Colombia, the country, actually used ChatGPT to look up some facts about some psychological issue or something. And I think that's fairly problematic. Honestly, I think that probably is not the type of diligence that one needs to do to satisfy one's obligations, one's professional obligations. But it raises interesting questions, right? That it's so easy to find answers, but in the same way that we're not going to cite Wikipedia as a reliable source when we cite in say a court filing. Similarly, I think we can't cite, oh, ChatGPT gave me this answer, and so I'm going to refer you to that as my source.
Yeah, no, I mean, that definitely makes sense. And it's something to be aware of as we kind of figure out how that can work in our practices. On a related note, and talking about being a strong writer, taking advantage of all the resources out there for you. So if I'm the kind of lawyer that's a little bit more hesitant to try the latest and greatest thing, I'm not going to integrate ChatGPT yet. I'm not going to jump on the Westlaw AI bandwagon. But I am interested in, I guess, tools to make my life easier. I mean, I know there's various form databases out there. Westlaw has one. Other online sites have them. And so I guess what I'm getting at is for somebody who wants to use forms and those kinds of resources to improve their legal writing and kind of streamline their process, I mean, is that a viable alternative, or is AI better? Are they equal parts? How much work does that save you?
Absolutely. I think I would describe those as sort of, they're not primitive, but they're more original, the more traditional ways of ensuring that, there are checklists and forms and templates and stuff. And I think those are valuable resources for ensuring that you're producing a document that contains all the components that it needs to contain, or that you're thinking through everything that you need to think through. And those are really valuable. And I don't want to discount those. I think that that many people, rightfully so, are going to be hesitant to adopt AI and ChatGPT, at least as far as they know that they're using it. They're not going to go out of their way to use these technologies. And I think that's going to be fine for a while, but I think probably within the next 5 to 10 years or so, we're going to see more and more that you need to use some of these advancing technologies to meet your obligation of diligence, for example. I mean, take, for instance, KeyCite and shepherdizing. If you don't shepherdize a case, you don't key cite a case, and it's been overruled, very recently, that falls on you, right? That's a problem with your diligence and representation. And I think that that means that you are required to adopt these no longer new, but they were new at one point, technologies, right? And so I think at some point, AI, whether it's ChatGPT, probably some other iteration of that, is going to be almost a necessity of legal practice. Whether that's in 5 years or 10 years, it's hard to say. But I do think that while we can certainly rely on these traditional tools, we should continue to look forward as well. And lawyers are notoriously bad about looking forward rather than holding on to what has been done, because that's sort of the nature of the profession.
Yeah, no, I'm with you. I was going to say the same thing. As a lawyer, I can say that notoriously we're slow to adapt to change. So I suspect it'll be on that 10-year mark. Before we kind of move into some of the other discussion points we do have a poll for the audience, and we'd love to get some of your input and thought while we're having this discussion on ChatGPT. So there's 2 questions here. The first one is related to sentences. So we've got four options here, and we'd love for you to tell us which one of these sentences you think that ChatGPT wrote. And then the second one is just your opinion. I mean, how do you see AI affecting law practice? Do you think it's going to take 10 more years? Do you think it's a tool that will replace lawyers? We've given you a few options, and we'd love to know which one of those resonates most with you. So we'll give you a minute or two to kind of look at those options, send in your thoughts, and then we'll look at the results together. While they're answering those, I'm sitting here thinking which one I think. And, hosts and panelists unfortunately can't vote, but I'll be interested to see whether or not we all agree. Nina, if you want to close that poll and share some results, we'll chat about them real quick.
Yeah, perfect. So the results for the first question, the majority of people chose C. That was 38% of you chose C. The second closest was A. So that was the second closest answer. David, did you want to reveal what the correct answer was?
Absolutely. So I'm impressed that 38% of you were correct in guessing C. So this was an interesting one for me to write that question, because I wrote A, B, and D myself, and then asked ChatGPT to write one as well. And I mean, they're almost indistinguishable, I think. I mean, they do I think they're very, very similar. And there's nothing in my mind that really gives away C. There's nothing that I can quite put my finger on as to why it doesn't feel as human, but the sort of my gut tells me, and it seems that many of you agree that it just doesn't feel as though it was written by a human, and it's not completely clear what it is that is. And I think that's probably indicative of a lot of the writing that ChatGPT is producing right now, is that there's something slightly off about it. We just can't quite put our finger on what it is. And sometimes it's obvious. I was thinking about, what kind of questions could you ask it to trip it up and make it clear that it is AI rather than a human. And I think we can all it's fun to brainstorm those types of questions. And but I think it's going to get better and better at that. And I think I wrote this question in part to indicate how good it is at some of these types of tasks, especially when it's very specific and the question or the prompt is narrowly tailored to the answer that you are kind of expecting it to produce. And I'm sorry, I didn't see the results for the second question.
Yeah, let me go ahead and see if I can share those now. So for the second one, the majority of the people, 89% of you, voted B, to be a tool for lawyers to improve their productivity and efficiency, and the other 11% voted C, to improve public access to courts and law.
Okay, great. And that is exactly what I expected the votes to be on that one. I can't imagine a room full of lawyers would vote to expect AI to replace them. And I think I definitely think that we are a long way from there, if that's even ever going to be a possibility. I think that there wasn't a single right answer to that question. I was really interested to hear your thoughts on kind of the future of AI. And I think it's right that AI for the foreseeable future is something to embrace as a tool, particularly in the hands of lawyers, experts, to make their work more efficient, so that they can spend less time doing that, first draft of something that they have to do over and over again, and spend more time on really making it exceptional. And I think that's going to be for a long time, that's going to be the human touch of taking something that maybe was created by AI and then making it really good, making it human. And I think that's probably going to be the relationship that we have, both lawyers with AI, but also I think the human race really is with AI is sort of as interacting. I talked earlier about sort of this conversation that I had with ChatGPT, where I asked it a question, it gave me the wrong answer, and I corrected it, and then I asked it a follow-up question, and it had course corrected based on the feedback that I gave it. And I think if we view AI and ChatGPT specifically through the lens of this is a dialogue, this is a conversation, that we will come to sort of grow alongside it and figure out how we can both improve with the help of each other. And that sounds very very touchy-feely, but I think that's a great and an important way of viewing this technology, because if we ignore it, I think that's to our detriment. If we put it up on a pedestal, I think that's also not called for. I think that's too much. But I think if we had a sort of conversation, and especially when it comes to producing content, doing writing, that we will all be able to improve in a way that's much more efficient than the means that we've had previously.
Yeah, that's awesome. And definitely some good insights. And I loved seeing what everybody and the audience here had to say today. I do have one more kind of discussion point for you before we start taking those audience questions. And that's a little bit more about those tools that everybody's more familiar with, that have been around a little bit longer. So, you've got built-in spell check into Microsoft Word. You talked a little bit about Grammarly Online, and sure, WordPerfect has its own version of these things. And so I guess for somebody who's trying to streamline their practice while making things more effective, I mean, we all trust and rely on those tools. But the question for you is, are they superior to each other? Is there anything to watch out for with those? Or, are they something that we can pretty well say helps you improve your writing and improves your practice?
Yeah, I think that they're all important tools. And I think one of the considerations is going to be cost. So for most of us, law students, but also lawyers, most people have access to Microsoft Office already, because that's sort of the most commonly used word processing tool. And so they already have access to spell check and grammar check. And so that's pretty good. And I think Grammarly is slightly more sophisticated, although it has its own limitations as well. So the free version of Grammarly can do basic spell check, grammar check, and so on. But you miss out on some of the things that I think Grammarly really has to offer, like tone detection and suggestions for full sentence rewrites, suggestions for consistency throughout a document, like spelling or the term that you use to describe something. And so those aspects of Grammarly, the premium version of Grammarly, I think are sort of a step up from what Office currently offers. That said, as we know, Microsoft is an investor in ChatGPT, and they've already announced integration with Microsoft Teams as sort of keeping meeting minutes, setting agendas, and so on. So I think it's just a matter of time, or probably not very much time at that, before we see Microsoft implements AI or ChatGPT in other aspects of Microsoft Office, in which case maybe that's going to be sufficient for all of our needs. I was sort of reminiscing about Clippy, the paperclip assistant who used to be in Microsoft Office. And I think Clippy is probably going to make a comeback in the form of a more sophisticated AI that helps us. Originally it would say, it looks like you're drafting a resume. Would you like help with that? I think the suggestions and the observations that it's going to be making, or whatever assistance happens to be, will be much more sophisticated, much more complex, much more helpful ultimately. So I'm excited to see what direction that goes and what it looks like.
Yes, no, I think we're all excited about the return of Clippy. I know I would be. That was my friend. So with that kind of said, I'll end our discussion here. I'm going to hand things back over to my colleague, Nina. She's going to take some of those questions that you guys submitted from the audience during the course of this presentation and let David give y'all some more specific answers.
Wonderful. Thank you again, Marina and David. We will now take the audience questions, as Marina mentioned. If you do have a question for David that you'd like to ask, feel free to click that Q&A button in your control panel and submit that question to us. It looks like we already have a few, so I can go ahead and dive right in. Our first question for David is going to be, is there a risk of the content ChatGPT produces having bias or discrimination in it?
Absolutely. And that's a risk with any sort of AI system, because AI learns based on a data set. And if there are biases within that data set, then those biases get reproduced in the content that the AI system generates. And so that's something that I think the developers, but also sort of the regulators have to watch for, is ensuring that that we're looking at the data that these technologies are learning from, and if there is bias in the data, that we do something to counteract that so that we don't perpetuate it. And sort of the same thing goes with misinformation as well. So we're already saying that if ChatGPT is learning from something that is simply not true, then it spits it back out as if it were true. And so we need to be very careful in checking for that, to ensure that we don't perpetuate misinformation or bias.
Absolutely. That makes complete sense. It looks like our next question was more related to the presentation. You mentioned plain English. What exactly is that? Why is it important?
Absolutely. So plain English, and so there's sort of two connotations of that. In more colloquially, plain English really just refers to understandable language that doesn't have too much legalese, that just your typical layperson can understand. There's also a movement among government employees. It's called I forgot the name of it actually, but it's just called the Plain English movement, I think. And it's aimed at educating and training government agency employees to use plain English or more understandable language in government documents they're producing, whether that be regulations or manuals or guidelines or anything like that. And so it's an unfunded set of volunteers who are doing this, but they're really committed to improving access and improving understandability of government's documents for the general public.
Awesome. Thank you. It looks like we have time for a couple more questions. So the next one is, if I use ChatGPT, how concerned should I be about plagiarism?
I would say that if you use ChatGPT to produce content for you, you should treat it as though it were a first-year law student producing content for you and edit it with a heavy hand. Make sure that you check all the facts. Make sure that you check all the legal conclusions. Check for grammar and spelling and citations and all of that. I mean, I think it's as we've talked about, it is a tool. It's a valuable tool, and it can save you a lot of time. But its reliability is very low right now. And so definitely review anything that it's producing, especially if you plan to use it in a court filing, on your website, anything that's public, anything that has your name attached to it. I would say make sure that you exercise great diligence in ensuring that everything is factually true and legally correct.
Okay, perfect. It looks like our last question for the day is related to Westlaw. I know you and Marina discussed that a bit already, but the question is, what are Westlaw forms, databases, and dockets good for?
So Westlaw forms, databases, dockets, and so on, can help you find examples of whatever kind of documents you may be looking for, and sort of serve as the foundation of whatever you're trying to produce. But it's not, unlike with some of the other more sophisticated tools, it's not going to auto-populate things for you. You really have to fill in all of the specifics. And so it's good. I mean, I think of it as sort of a template, or a blank form that you can fill in all the specifics. But it's not It's one of the more traditional or conventional tools that we have to help us. Not one of the more cutting edge where you just say a few things and it generates the whole document for you. So more reliable, less, but also more work on your ends to fill it in.
Wonderful. That looks like all the questions we have time for today. Thank you again, David, for being here, for the discussion, your presentation, and all of the questions. I will go ahead and hand things back over to Marina just to wrap up our webinar today.
Great, thank you.
Thanks for being here and have a great weekend.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.